So the public charge is gone. Yes. On March 10th, the USCIS removed I-944 from its website. This is the form that was used under the new public charge rules, declaration of self-sufficiency, all the supporting documents that we needed, that is gone. I also made a video a couple of days ago that explains what happens with cases that were filed before this rule was removed, and what happens if you receive the request for evidence. What do you do now that this rule is gone? So that's all in that video. But in this video, I'm going to break down even in more detail what to do if you file the applications before March 9th, when the public charge forms were removed from the USCIS website. What happens if you receive the request for evidence in more detail? How do you respond if you have a mix of requests for evidence based on public charge and part of it is not related to public charge? And most importantly, how are you going to file your cases from now on when the public charge rule is gone? How it's going to look like moving forward. I'm also going to mention what to do if you filed an extension of status for a tourist visa or for any other non-immigrant visa, which also required some elements of the public charge rule. So make sure, once again, you stick to the end. Hello everybody, and welcome back to our immigration channel. This is a place where you get the most up-to-date immigration news, immigration updates, and everything else that you need to make your immigration journey less stressful. My name is Jacob Sapochnik, and I'm an immigration attorney based in San Diego, California, and I help clients in all 50 states. If you're here for the first time, make sure to click the notification bell and subscribe to our channel so you don't miss any of our videos. And also give us a big like so YouTube will be able to share this video with more people just like you. So let's talk right now. What are you going to do moving forward as you're about to file your application for adjustment of status or any other application to change your status inside the United States that required previously information connected to the public charge? So if you're filing an application on or after March 9, 2021, you're going to do the following. Applicants filing after the date should not submit Form I-944, Declaration of Self-Sufficiency, or any other documents supporting this application. You don't need to do so anymore. USCIS also stated that they are not going to reject any applications that include this I-944 and the evidence or exclude it. Essentially, if you're not going to include it, you'll be okay, and if you're still going to include it, you're also going to be okay. Number two, if your application was filed before March 8, 2021, but USCIS was going to be adjudicating your cases after March 9, 2021, USCIS said they're not going to consider Form I-944 or any supporting documents related to this document. They also said that any other information that you provided there would be adjudicated with the current policies that they have in place, which means basically we're going back to the 1999 policy where all you have to do is submit an affidavit of support, I-864, and meet the income requirements under the poverty guidelines. Now, number three, if your adjustment of status application was filed before March 8, 2021, but you received a request for evidence or an intent to deny, specifically to the public charge elements, your reply is due after March 9, 2021. USCIS stated that you do not have to respond to any of the elements of the request for evidence as they pertain to Form I-944, Declaration of Self-Sufficiency, or any of the supporting documents. So if your request for evidence specifically asking questions about I-944, you don't meet the requirements, you can ignore this RFE as it pertains to I-944. If your request for evidence has other elements, for example, they are questioning your eligibility to adjust status, maybe your birth certificate, maybe other issues, you still have to respond to this RFE. Just ignore the sections that pertain to I-944. It is really important. Do not ignore an RFE if it has other elements outside of the I-944 scope. Otherwise, your case will be denied. If the USCIS is going to require more information about your financial ability to support your immigrant partner, they're going to issue a separate request for evidence that will be based on the previous guidelines from 1999, specifically with respect to the I-864. My recommendation in any case is just respond to all the RFEs that you get, no matter what it is. Respond. If it specifically pertains to the I-944, just download the guidance from the USCIS website. It's right there. If you Google a public charge USCIS, you can see that it specifically says everything that I'm just mentioning here. Download that, put it in your RFE and say, here's a response. We don't have to address I-944. and that's it, and keep a copy of it. The reason is because in case your case will be denied for lack of response, you'll have proof that you did reply with this particular guidance that I mentioned right now. Now, let's talk about extension of status. What if you extend your tourist visa in the United States? What if you change status from a tourist visa to a student visa or work visa extensions? If you filed your I-129 forms, I-539 forms, if you filed these forms after March 9th, 2021, you don't have to provide any information pertaining to public charge, specifically, for example, on Form I-129, which you use for extension of status for your H-1B or all visas or whatever work visa you have. Part 6 talks about public charge. You can ignore this. If you're filing for your tourist visa extension, Part 5 of Form I-539, you no longer need to provide that information if you file your applications after March 9th, 2021. If your applications for change of status and extension of your work visas was filed before March 8th, 2021, USCIS stated that they're not going to consider any information pertaining to public charge on any of these applications, and if they need further information, they will contact you. Finally, if you filed your applications for change status, extend your tourist visas, or any other non-immigrant visas before March 9th, then you receive the request for evidence after March 9th with a later adjudication date. You don't have to worry about responding to any elements that pertain to public charge. But as I mentioned before, I still recommend that you do respond, download the guidelines from the USCIS website, attach it to your response and say, here's my response, I don't need to address any of the public charge rules based on your guidance, and there'll be a safer route so you have some proof that you did respond and not leave it unanswered. So as you can see, there's a lot of confusion in this area because a lot of people were really stressed out by the public charge rule. As you remember, we had to provide credit reports, we had to provide proof of income, educational elements. There's so many factors that came into this, and it made it very difficult for so many people to apply for green cards. In fact, there are quite thousands of people that were denied their adjustment of status applications because they couldn't meet the requirements of the public charge rule. Therefore, the elimination of this rule is going to help so many people. It's going to bring justice back to our system, and it's going to make the process more streamlined in the next few months. But remember, in the meantime, there's a lot of confusion, and therefore I wanted to create this video so you can understand what happens if you filed your application before March 9th when they removed the public charge rule, what's going to happen if you have a request for evidence and intent to deny. Remember that it is important to be methodical, to be consistent, look at your applications. I still think that you should respond with a simple statement stating that public charge information is no longer required. Here is a printout from your website stating that exact facts. Please continue to process my application, and if you need any further information, you can ask the government to contact you and you will provide it. So best bet, always respond to the RFE, but make sure to remember that you don't have to address the public charge element anymore. Once again, hopefully this information was helpful. I made this video because so many of you in the comments and in text messages were asking me about this and were confused. So hopefully this information is beneficial. If you're here for the first time, don't forget to click the notification bell, subscribe to our channel, and share this video with somebody that may need this, may benefit from this important information. Don't forget to give us a big like so YouTube will be able to share this with more people just like you. Remember guys, a lot of you are confused about immigration, have questions about this. Don't forget that we have a Facebook group that is specifically designed to address these questions. We have a lot of public charge conversation going on over there. The link is right here on the screen to join our private Facebook group. I want to see you on the other side. I want to talk to you over there. And also the link is in the description of this video. And as always, if you want to have a one-on-one consultation with me, remember this video is not intended to be legal advice. This is public information. I'm doing it for you guys every week because I'm passionate about immigration, because I want to help people, and because I'm encouraged by your comments and by your support for this channel. If you want to talk to me one-on-one, all you have to do is send me a text message right here, 619-483-4549. We can set up a proper one-on-one and we'll discuss your case in more detail. Thanks for watching, and I'll see you in our next video.